You likely didn't hear about this story. Well, why would you from corporate media? Thank goodness for the Epoch Times, who broke the story a couple of weeks ago about a decision last month by arbitrator Nicholas Glass in the Purolator case in British Columbia. In the case, the arbitrator ruled in favor of unvaccinated Purolator workers. Now, former British Columbia Attorney General Suzanne Anton stated that she thinks this could be a game changer that could not only wipe out vaccine mandates for healthcare workers in the province, but may also help in another lawsuit, one filed against BC Provincial Health Officer Bonnie Henry by a group of unvaccinated health workers. The doctors, nurses, and other healthcare personnel who were fired for not receiving COVID-19 shots are still asking BC Supreme Court to remove the province's vaccine mandate so they can return back to work. Yes, folks, there's still a vaccine mandate for healthcare workers. It would appear that the Purolator case was a game changer, and by all accounts, the first time that a person in charge of rendering a decision has not only ordered compensation, but more importantly, called into question the conduct and behavior of the British Columbia public health officer. After a year-long arbitration process, Mr. Glass last month ordered Purolator to compensate employees who said they were terminated for not receiving a COVID-19 vaccine. The order applied to members of Teamsters Local Union 31 in Prince George for any lost wages and benefits between January 1st, 2022 and their first day of work after May 1st, 2023. Whether the arbitrator's decision will be recognized by others remains to be seen. If it is, it could potentially signal the end of BC's ongoing vaccine mandates, both as mentioned current ones and potentially quash any future ones. Now, in case you forgot, courts and arbitrators in BC thus far have been quick to back the decisions of public health officials, regardless of evidence presented by those that oppose such mandates. Purolator introduced a policy on September 15, 2021, requiring employees to be fully vaccinated against COVID-19 by November 1st, 2021. Employees who failed to comply with the policy or failed to qualify for an exemption were placed on unpaid leave as of January 10th, 2022. Purolator did not suspend its COVID-19 vaccine mandate until April 13th, 2023. It asked employees who had been placed on unpaid leave at that time to return to work by May 1st. In this decision, while Mr. Glass found that the original mandates were justified based on advice from public health authorities, Purolator was obligated to pay attention to health advice as it changed. After March 2022, the arbitrator noted health authorities were no longer saying that a 2-dose vaccination after 25 weeks was of any value in protecting against infection. That led Mr. Glass to conclude that the unpaid leaves of absence ceased to be reasonable as of June 30th, 2022. During the arbitration, the union challenging Purolator brought in a top expert in the field of immunology. The immunologist testified that the COVID-19 vaccines in use provided no reliable protection from infection 60 days after the second shot. In his decision, Mr. Glass said this evidence was both overwhelming and persuasive. Mr. Glass also commented that he found Dr. Henry's health orders relating to vaccine mandates startling and important observations. Mr. Glass stated that in a September 12, 2022 order, Dr. Henry said, an unvaccinated person is more likely to become infected than a vaccinated person and is more likely to transmit SARS-CoV-2 than a vaccinated person. Language, believe it or not, that still exists in the current order. He concluded that her statement was wholly inconsistent with the preponderance of material he was presented during his case. Bear in mind that arbitrations are not binding in a way that court decisions can be, but at minimum, they're influential. Will other judges presiding over cases piggyback off Mr. Glass's conclusions? One can only hope so, and only time will tell. I'm guessing unvaccinated healthcare workers in BC who were fired over 2 years ago are certainly hoping that's the case. Unvaccinated healthcare workers went from heroes to zeros pretty much overnight, with some, as I said, being forced to retire, while others had to start all over again in private health facilities or in a new province altogether, while others to this very day remain at home with shattered lives and no income stream. Based on Mr. Glass's ruling, what can you conclude other than that the province's decision to keep the mandate in place is and was purely political? And before you lay all the blame for this draconian policy at the smelly feet of Dr. Bonnie Henry, it's ultimately Health Minister Adrian Dix and Premier David Eby who can put an end to this insanity anytime they want to. Something all of you need to remember at the time of the next provincial election. With the majority of the fired workers involved in the litigation against the province, if future decisions have similar outcomes, it's going to be very costly for us BC taxpayers, who will ultimately be the ones shouldering the cost for these malevolent decisions of BC policymakers. I can hear it now. These whiny, sniveling bottom feeders. Come on, who could have known? That's what they'll say. After all, we were just doing the best we could with what we knew. We were just following the science. No, my dear friends, you were just following the money. Anyway, I do appreciate it. Thank you for watching. I do thank you for any comments you might have to share. Follow me on my Rumble, my Locals account. If you haven't yet subscribed to my channels on Rumbles, Locals, YouTube, jump on board. I'm also on Twitter, X, at Camera612, and I will see you next time.